Okay.
We can go ahead and get started.
Okay. Yeah. My camera angle is still off. I don't know what's going on with that. Not a problem. It's not about me. It's about the deck, right? So what we're going to do is, whoopsie, try to figure out which button I need to hit first. Share. That was not it. Sorry, guys.
You're good. We don't need to see the secret emails.
Okay, can you see my deck, Matt?
Not yet, no.
Okay. I may be having more problems than just my camera angle then.
Zoom calls with this week have been issues. Yeah. But like I told you, mine updated. They don't feel bad. So it canceled all my Zoom calls. Like I had to reschedule everything. It canceled everything.
Oh, that's it. You know, we went through a similar update over here and it's been a challenge, no doubt. Okay, I'm just going to use my other monitor. I apologize to everybody listening if it looks like I'm staring off into the North 40, but uh that's where my deck's at. So let's just get cracking, shall we?
Yeah, we're good. There you go. Yeah.
All right, is that better?
Yes, we're seeing now.
All right, everybody. Okay, if you don't mind, we're going to dive right into this. So, good morning, everybody. I'm so glad those of you who could make it, you're joining us for what is, in my opinion, one of the best topics ever, and that's estate planning for business owners. This is going to involve a little bit of tax, a little bit of legal, and hopefully a lot of practical application because that's what Matt and I wanted to do when we came together and talked about, what this looks like. What we want to do is share information for you so that you can make decisions on your end. So this is purely educational and to give you a little feel for my background, to prove that I can be here and I can talk about this topic. So I am an estate and business planning attorney. I have been for nearly 30 years now. And when I started my practice, I was a drafting attorney. So I would draft the documents that we're going to talk about today. That for me was a little laborious. So I kind of flipped over to the consulting side. So what I do now is I support folks like Matt to help, strategize, analyze, and help clients look at the plan in terms that are simple and to strip away a lot of the legalese and let's just get down to the nuts and bolts. So with that, let's get down to the nuts and bolts. This is our agenda for today. What I want to do is start with the foundational documents, right? What is an estate plan? What does it look like? How do you get started? At the end of the day, what does it do for you? Next, I want to talk about the business interest in the estate. I think that there is a fallacy in our industry where planners treat business interests in the estate as if it's just another estate asset. And I disagree with that. I think that you need to be very careful with those interests in order to protect the business and ultimately the family. Third, I am an attorney, so I cannot count. Numbers confuse me, but I got the concept for you. So Matt will take care of numbers. The lifetime business transfer, we're going to talk about when you transfer a business, in other words, when you leave the business and give it up to the next generation, or maybe even a third party. We're going to look at the common techniques that are used for that and the rules that you need to keep in mind as you're working through that analysis. And then finally, the Connelly impact. We had a bugger of a case come down in June 2024. It's the Connelly. The Connelly case really made an impact on business planning. And it's something that you need to be aware of. And yet it didn't hit the major news channels for headlines. It just is, a hurdle in the road. And we got to be able to clear that. So these are our four items that we're going to tackle today. And with that, I'm just going to dive in. Matt, do me a favor on your end. If a question comes up, will you stop me and we'll address that question as we go?
I don't think the slides are moving either. Like we're still
What?
on.
What do you see? Do you see the agenda slide?
No, no, estate planning for business owners.
Okay. All right, because it is moving on my end. So forgive me. I am going to try this again. Share. How's that?
You know, we got it now.
You do? You have it?
Yes.
Beautiful. All right. Um, Foundational estate documents. Let's look at what the so-called estate plan looks like. So estate plans are created and implemented using legal documents. And typically, when you go in and talk to an attorney, um, they will come back with their product, which is a packet of documents. They usually put it in a binder for you, or they put together an e-file for you. And these are the typical documents that you see as a foundational plan. When I say foundational plan, this is like elemental. This is your keystone. This is what you need to get started. And then when you're doing more advanced planning, that's when we start to bring in things like holding companies, irrevocable trusts, dynasty trusts. That is a topic for a different day. Let's talk about these three items. So, the attorney that you want to talk to should be an estate and business planning attorney. This is a specialized area of the law. You don't want a litigator, you don't want a real estate attorney, you don't want a corporate attorney. You need an estate and business planning attorney. I liken it to if you need your appendix taken out, you don't go see your dentist. They're just not set up for that. You need to see an estate planning attorney. Normally, well, I shouldn't say normally, the industry standard is when you go in to see that attorney, they normally don't charge for that consultation. Attorneys in my discipline, my practice, we charge by a set fee. So you get your documents, and there's a set fee for those documents. Sometimes they'll increase the fee if there's freelance drafting in there that they have to do because of special requests. So ask them what their fee is. Ask them, what is this going to cost me to get these foundational documents? Now, attorneys also will default to the will, and then they may switch over to a trust. That's why with that first box, you'll either get a will, so last will and testament, or a trust, revocable or living trust. And we're going to get into the details of each of those. But we're going to start with the will. Okay, what is a will? You know what? A will is when you boil it down to its elemental level, a will is simply instructions for the probate court. So if you pass away and you have assets that don't go by beneficiary designation, I should say, or by contract, for example, life insurance, we have beneficiaries named, both primary and contingent. If we don't have a beneficiary on those types of contracts, it goes to the estate. But the probate court has to have instructions on what do we do with these assets if they come to us. So a will is something that you put together. It's customizable. You are the master of your plan. And if you want certain things in that will, this is where you you talk to your attorney and they make certain that they incorporate these wishes in the will. Um, to visualize, what if, for example, you have a child who might be a spendthrift? I've got a couple of those in my family. And we make certain that in our documents, the will puts some guardrails up so that that spendthrift individual, that individual who's not good with money, they're restricted in how they use the funds. Or you might want to get creative. I had a client who she was Irish. She was passionate about pretty much everything she did, even how she was going to die. And we put together instructions in the will that told her family how they were going to have a wake at the end, right down to the type of whiskey they were going to bring to the table. So these are the kind of things you want to think about before you even go in and talk to the attorney so that you've got a feel for how are you visualizing that last chapter, and then make certain that the attorney builds that into the document. You're going to need to name executors or personal representatives. Those terms are exactly the same. It's really a practice preference on the attorney's part. When you do that, think about the people in your network, your trusted people who are good with numbers, they're good with details, and they'll be able to take the reins and move the family through this process. This is also where if you have minor children, you can name the guardians in this document. Now, I want to pause there for just a second because a lot of jurisdictions will allow what we call standalone guardianships, which is, it's a 2, 3 pager. The attorney drafts it, you execute it. They're cheap. I used to do these for like $200 a piece. And what they are guardianships that you set up for your kids without the will. So you can do an either or on that. Now, I said initially that the will is something that most practitioners, most estate planning attorneys default to. The reason for that is this. It's typically less expensive to set up, and the details don't need to be managed. You put it together, you put it in your safe deposit, not safe deposit box. Sorry, we're going to get to that. You don't put it in the safe deposit box, you put it in your safe place in the house. Um, and then the probate court takes over and uses it in order to manage the estate. The reason that they don't start with the revocable trust is because there's more cost involved in setting up the revocable trust. I'm going to sidebar just real quick. The safe deposit box is a real issue. Think about it. If the will is in the safe deposit box, but you have passed away, there's no way for the family to get into that box without going to the court and asking for permission. So the safe deposit box is a really lousy place to own these documents or hold these documents. The house, wherever you keep your other important documents, that's a good place for it. So yeah, just sort of a public service announcement on my part. We're going to get into revocable trusts, okay? Revocable trusts are also called living trusts. I have some practitioners that call them family trusts. Whatever they call them, it is a trust. It is a revocable trust. A revocable trust is an alter ego of you. So, from a legal perspective, you and this revocable trust are the same thing. The key to a revocable trust, however, is that you have to make certain that everything that you own is titled in the name of the trust so that it holds the assets. And when you go through your annual review at the end of the year with your financial advisor, what you want to do is bring a list of any of the new toys, any of the new properties, any of the new business interests that you collected over that last year to make certain that titling is proper if you have a revocable trust. This is why a lot of practitioners default to the will, but they'll use a trust for specific situations. We use a trust when we have multiple properties in multiple states, because if you have that scenario, you're going to have multiple probates. and that could be a problem. It could be a problem because with multiple probates, you have multiple cost, multiple processes that your executor has to go through. So, man, that can be a cumbersome, that can be a part-time job, really. So that's why multiple properties, multiple states, we look at a revocable trust to bring it all in, because with a trust, you don't have a probate at all. You completely avoid probate, which is why we use a revocable trust when we have beneficiaries that might cause some problems for the family. If that's the case, then a revocable trust is a really great option. It doesn't matter if you have, you know, $10 to your name or 10 million bucks to your name. Revocable trust will keep the family out of probate. It takes away that public forum for beneficiaries who are going to cause conflict. Also, and I really like this point, revocable trusts are absolutely confidential. There is no public record, whereas a probate is fully public. It's a public matter. And your assets, your inventory is a matter of public record. Not so with revocable trust. Nobody knows what's happening unless they have an interest in the trust. All right, beautiful. So um, again, you are the alter ego to this trust, so you control the assets during your lifetime. And then at death, what happens is the successor trustee steps right into your shoes. Even in a disability, the successor trustee steps right into your shoes and manages all of the assets as if nothing had happened. And that's helpful when you have a situation where maybe you need that streamlined transition over to somebody who can manage things. For example, when you own a business and you need somebody to step in right away, because, and we'll address this later on, when you have a probate, business interests, business operations they're stopped. They're paused until the probate court can work through all of the logistics, all of the details, and make certain that they're comfortable with the person who's going to take over. So, yeah, a revocable trust can help in that scenario. And then finally, you have distributions to the beneficiaries. Like the will, you're controlling that through the revocable trust. So there's not a great deal of difference there, except that when distributions are made to those beneficiaries in the trust, they're made by successor trustee. In a probate, they're made by the personal representative by the court's blessing. So they have to wait. The PR executor has to wait until the court gives them the authorization. All right, beautiful. This general durable power of attorney, or really power of attorney, is probably the most important document in this packet of documents you're going to get from your attorney. I say that because this impacts you and the family while you're alive. And when there's a disability, this is where things get really difficult. And the power of attorney will help your family stay out of court to get permission from court to control assets and make decisions for you. So with the power of attorney, what you're doing is you're tapping someone, you're naming someone to step in and manage assets in the event that you cannot. And this is regardless of whether it's a temporary disability or incapacity or a permanent disability or incapacity. Now, it's important to note there are two forms. The form that's used the most is the immediate or durable. That's why it's called durable. The immediate agency allows that person that you've tapped to step in even when there isn't a disability. I know that might be a little scary, but the springing POA, I think that's even scarier because with the springing, you have to have someone certify, you have to have a physician certify that the incapacity has happened. Now, we've seen some challenges with that because doctors don't want the liability of making that certification. And even more laborious is the fact that Oftentimes, those powers of attorney require two doctors to agree that there is an incapacity. And that is really difficult for the family to do. So most practitioners start with the durable or the immediate power of attorney. And that's the one that you're going to see probably more often than not, unless you ask for the springing. So this power of attorney handles financial affairs, gifting, estate strategies, transactions for the business, it's property. Now, this is going to be effective for your lifetime. When you pass away, it's no longer effective. It ends at death. And a lot of clients miss that point. They think that this will also allow somebody to manage things after death, and it does not. At death, this one ends, the power of attorney ends, and the will or the trust begins. Now, that doesn't make sense. Let me correct myself. Excuse me, but since this is being recorded, um, the revocable trust begins when it's executed and continues on, but things will change inside of the revocable trust at your death. Okay, point of clarification. All right, healthcare directives. Now, the power of attorney handled the financial matters. The healthcare directive handles the healthcare matters, the decisions that your family will need to make in order to manage the events at the hospital during that twilight period when you need health care and you can't make those decisions for yourself. What you've done with this healthcare directive is you've named the people that you trust to make these decisions for you. Now, and again, this document has both, the immediate version and the springing version. The immediate version is the one that we see the most. So that's probably the one that your practitioner, your planning attorney will default to. Now, we typically see individuals named, not groups of individuals. So oftentimes a family will have multiple children. You have two, three children. You want all three of them to make a decision together so that the one doesn't have the burden of making healthcare decisions. Think about that. Think about how that's going to play out. If those three kids can't make a decision quickly, then that could be a bit of a hurdle in the road to clear in the event that you need decisions to be made quickly. And so maybe, a successor, the first kid, second kid, third kid, you got three deep on the bench. Maybe that might be a better way to go. I don't know. Talk to your attorney and see what they think about that. So, healthcare directive, like it says, all healthcare matters. The powers to control financial matters won't be in this directive. This is all healthcare. So, it goes by many different names. In my jurisdiction, which is Minnesota, we call it an advanced directive. It's a healthcare directive. You may have medical durable power of attorney. Long story short, if it deals with healthcare matters, this is what they're talking about when the attorney puts this document together for you. Okay, like I said, business interests in the estate, they are a special asset and they have special rules that apply to them. So when you're working with your financial professional like Matt, like Scott, we have rules that we as planners, as consultants, have to keep in mind as we're strategizing and trying to build out a plan for you. One of the primary rules is the value of the business if owned by the decedent, by our client. The value of the business is included in the estate, which is why we're analyzing what is the value of your business. And when we talk about analyzing the value of the business, you do not need a formal value in order to do this type of planning. An informal valuation is allowed, which is great because that saves thousands of dollars in getting not having to get that certified valuation. Now, the estate taxes for the IRS is due 9 months from the date of death. And so at death, the clock starts to tick, and IRS will want their taxes, a check for the taxes, 9 months from date of death. For business planners, this is a major issue. We call it the fire sale. We do not want a fire sale on assets in the business in order to pay taxes, which is why we try to plan in advance so that we know what are the taxes or estimated taxes that could be due and where are we going to find the liquidity, because we don't want to find the liquidity by selling assets of the business. Now, a benefit to our business owners is business interests, if included in the estate, receive a step up in basis. For a family, that step up in basis is important because if I had a business, which I don't, but if I had a business and I pass away, if I have some gain in those business interests and my daughter receives those shares at my death, she's going to receive those shares with a basis that is going to match the fair market value on my date of death, which means if she turned around and sold those business interests the next day, she wouldn't have any capital gains tax. If we didn't have this rule, if we didn't get this step up in basis, she would have gains, capital gains tax on the full spread of the gain that's in that interest that she has inherited. So we use this one a lot. Now, the key here is that it has to be included in the estate. In other words, if you move your business interest to, let's say, an irrevocable trust, it's not going to get the step up. If you gift your interests, it's not going to get the step up. And we're going to address that a little bit later on. Okay, we touched on this earlier. If there is a probate, operations in the business could be delayed. I have to put could be, maybe, hedging a little bit here because I have a compliance group that reads my slides and they're great. They're watching. You're great. But we put that in there. This is pretty much, yeah, it's going to be delayed. You're going to have a pause in operations so that the court can analyze and the court can decide who did you want to step in as your successor. And that takes time. It takes a lot of time. Probates in most jurisdictions take anywhere from 12 to 18 months to get through the whole process. And some of the delay is due to, this back and forth with creditors and waiting periods, but it's also because of probate courts, the court's docket. The dockets are typically very, very full. They have been ever since I started, so I don't see that as changing anytime soon. Okay, and then finally, another rule that we manage, if you sell the business on a note, so you don't own the business anymore when you pass away, but you have a note that somebody is paying on, say a child, then the remaining principal on that note is included in the estate. And it's included as income to the estate. So, we plan for that as well. There are some ways to cancel that out using cancellation features, but now we're getting advanced. And I'm going to pull back because we don't want to get that far into the weeds this early in the morning. Okay. Another issue that we deal with a lot is equalization. This is the scenario where a business owner, they know it's going to go to the kids, right? Let's say they have two kids, and one is very busy in the business. She's been involved from her day one, and this is her career. This is what she's going to do. She has a brother not interested in the business, and he's off doing his thing. He's a different kind of professional altogether. Will never be involved in the business. You need to decide, how are we going to be fair and equitable and protect the business as well as the kids. This scenario we see a lot when, mom and dad want to divide equally. So the daughter gets 50%, the son gets 50%, and they think everything's going to work out beautifully. Well, oftentimes it does not. And this is where we see a lot of businesses fold because we have this friction between the working child and the non-working child. The one who's not working is always watching over the shoulder, making, it's the armchair quarterback trying to figure out why the working child made certain decisions and why more money isn't coming out of the business. And you know the drill. So we try to put together plans that maybe use estate offset, which is where you give non-working child assets and the business to the working child. Or we use life insurance, create that liquidity so that one child gets cash, the other child gets the business, or a mix. So equalization is a big part of what we do. Let's talk about the business sale. So this diagram is this is sort of like the decision tree, and it includes the most common types of transfers. When you're initially looking at, and this is lifetime, so this is a lifetime transfer of the business, and you're trying to figure out who gets the business. Well, that's your first level of decision. Is it going to be the kids, or is it going to be a third party? If it's the kids, we typically see two types of transfer, installment sale and private annuity. If you're working or if you're looking at a third party, let's say your kids are doing something completely different and they're not interested in the business. With a third party, you're often looking at a purchase agreement. It's pretty simple. But before that purchase agreement, maybe you want to do a little bit of basis planning. Basis planning is where you're grooming your basis so that you're trying to reduce the amount of cap gains to you when that business is actually sold. 1202 it's the new darling of business planning world. 1202 is a qualified small business sale. What it is it's complicated, so we're not going to get too deep into this. But if you have a C Corp and you meet certain qualifications, you can exclude a lot of cap gains in the sale of that business. 1031, that's where you flip the business and you are getting a different kind of business interest. And so really, you're not excluding any cap gain out of, that year's tax return. What you're doing with that is you're deferring it for another time. So this is kind of your decision tree moving forward into this analysis. These are the questions that you need to ask yourself if you're looking at the transfer to next gen or the kids. Determine if you can afford to do this. A lot of my clients, they want to gift the business. They think that, that's what they can and should do. But when we run the numbers, that might not be in their best interest. So make sure you know what your numbers are and can you live on your nest egg without that business? Are you ready to give up control? That's a big part of this. Are you ready to give up control? And oftentimes, the answer is no. I'm not ready to give up control, but you know what? You don't have to in order to start the process. Maybe you give just a sliver of interest to, next gen. Maybe you give them 5%, 10%, and see how that works. See how that feels. This is part of the planning process. And then you need to decide how quickly or slowly do you want to get to your end game? In other words, what is your timeline? How do you feel about this? And then we work with that. The next is, does next gen, do the kids have the cash flow to make this happen? If we're going to sell to them, we need to know that they've got the cash flow, the wherewithal to make this happen. And maybe that comes from cash flow of the business, but remember, they have to have the interest in the business in order to take advantage of that cash flow. So here again, we need to crunch the numbers to see what that looks like. And will that alleviate some of the pressure on them to make this happen? And then sometimes it's not a matter of cash flow. It's a matter of, do they have the chops? Do they have the business acumen to make this work? And here again, what we see are business owners who will, do this one layer at a time. We call it laddering. So, maybe you have laddered installment sales and you give them 10% in one year, 10% in the next year, and year after year until they're ready to take full ownership. And what you're doing is you're grooming them. You're still there as 90% owner, and they're watching you as you really work the business, and hopefully they're taking notes. Man, I'm going to pause because we're sort of midway through. I just want to make sure that we're on good pace and make sure we don't have any questions that I'm ignoring.
I think we're good. You're doing a good job. I don't think any questions came up.
Okay, awesome. Let's move into the three common techniques used when we are transferring interest to next gen. So when we are tapping the kids as your successor, we see this done in three common techniques. The gift, which, yes, granted, not a sale, but I'm adding that because that's usually where most of the clients start. The gift, the installment sale, and the private annuity. All right, with the gift, you will lose that step up in basis. The kids will get the carryover basis. In other words, your basis will carry over to them. You, of course, lose control. That's self-evident. You're also losing the economic benefit of that business. Clients, there's equity and then there's cash flow or W-2, right? And oftentimes, my clients will give up economic benefit thinking that they can still get cash flow, but you can't unless you're actually working for the business. And then your cash flow flips over to a W-2. And so you need to understand that going into this if you're going to gift. Okay, one of the most common techniques that we see is the installment sale. The installment sale is going to stretch the payment over a period of time. And then any amounts that are not paid at death are paid to the estate. When we were talking about, ladders and doing 10% this year, 10% next year, we're doing that with an installment sale. And so you can do multiple laddered installment sales over a period of time. That way, we're easing out of ownership and into retirement. A technique that we use when there is an ongoing income need. In other words, you want to sell this to the kids and the kids want to buy it, but maybe the financial plan, the numbers are projecting there's an ongoing need for cash, or maybe psychologically that's what you need is an ongoing cash flow from the business. We do a private annuity in that scenario. This is not an annuity contract from a carrier. That's not what this is. This is it's actually a technique that the DuPonts used, and it backfired on them because Grandma DuPont she sold to the kids, and the kids bought it under a private annuity. They thought that this was a great way to remove some value from the estate. Because if grandma had died, even 5 years after they got into this deal, all of that value would go away, right? Because it's an annuity. But grandma lived to be like 143 years old. So the family ended up paying two, three times for the business what it should have been. And so, yeah, that backfired. But if you're working with a good financial advisor and a good CPA, we can usually get those numbers, in a spot that makes sense for both generations. So yeah, private annuity is where if you need an ongoing income stream, this is what we do. All right, moving right along. This is the initial analysis when we're looking at a sale to a third party. So that's the other side of that decision tree. Uh, we put this out there because a lot of business owners can miss this point if they're not counseled properly. We can do some estate planning involving this business if we start talking about the estate planning and implementing it prior to discussions with these third parties. What we're doing is called it's a capital management technique where You're moving interests into an irrevocable trust in order to allow that trust to go to the table to complete the sale. And we're removing these assets from the estate. We're allowing the proceeds from the sale to go directly into this trust. It's a great way to fund legacy for, the next gen. For example, what if you had a dynasty trust and you did this and you let the trustee go to the table to close out that sale? This has a lot of impact, but it's a timing issue, which is why we want to put this out there just in case you may be thinking about a sale. Talk to your planners and see if there are any estate planning opportunities that you want to take advantage of before you get into that discussion. All right. If you own interests in a business with another party, and it doesn't matter if that party is next gen, so the kids, or if it's, let's say it's another partner, you need to have a buy-sell agreement. And this one is super important. We talked about how the power of attorney was a critical document. Oh, well, this is a critical document as well. So buy-sell agreements create legal obligations. And the legal obligations are going to protect you when someone leaves the business, but it's going to protect your family if you're the one leaving the business. Now, what these buy-sell agreements say is, in the event of a disability, a retirement, a sale of the interests, or in the event of death, we agree to three different things. We agree to how will the business be valued? That's a big deal. How will the business be valued? Um, who are the relevant parties to this arrangement? And what is the process of that transfer? In other words, let's say that the buy-sell says the departing business owner will get their fair market value on their interests immediately. We need to be prepared for that. So we need to know that we've got cash in reserve, or we've got death benefit, or we are able to make that happen. If, however, let's say that the parties believe that they would like a little bit of time to make this happen and everybody agrees to that, that process will build in, for example, an installment type arrangement where you're pulling from cash flow every year in order to make a payment to the departing business owner every year um, um, for a certain period of time. There is an endpoint. We have to have that endpoint. So the elements of this technique require the actual buy-sell agreement. It's a written agreement. You find it in really two different ways. It's either a standalone, so it's a separate document all by itself that everybody agrees to, or it's sometimes built into your organizing documents, your member agreement if you're an LLC or a partnership, or your articles of incorporation if you're an S Corp or a C Corp. Sometimes attorneys will actually build this language right into those documents. It's really important to know how those read and to, do a run. I tell clients all the time, audit that thing, do a dry run and see what that looks like if you run your scenarios and make sure that it does what you want it to do. It reflects your vision. And then also know where the funding is going to come from. Is it reserves? Is it cash flow? Is it life insurance? Make sure you know where that's coming from. All right, beautiful. Three common techniques for buy sells are cross purchase, entity redemption, and then a hybrid of the two. So let's really zero in on the cross purchase and entity redemption. Cross purchase is usually done when you only have two business owners. The cross purchase will say, in the event that, business owner A dies, business owner B is obligated to buy from A's estate or A's spouse or A's named beneficiary. And then the survivor, business owner B, has to find the money to do that. And so they are agreeing to how this is all going to work out. The the corollary to that, the opposite of that, is when you have an entity redemption where the business is a party to this agreement and it agrees to buy from the estate or the departing business owner. So those are your two basic types, cross purchase, entity redemption. And then hybrid blends these two. It creates layers of rights of first refusal or options. So maybe the surviving business owner B gets the first right to make that purchase. And if they waive off that right, then it goes to the business, and the business will pull those interests into Treasury, and then you have basis issues and whatnot there. So, and again, to dive deeper is more advanced. That's for another discussion. But hybrid is very, very common. And so oftentimes when we see a buy sell and we have more than two business owners, it's going to be typically hybrid. So don't be surprised if that's what you've got. The Connelly impact had an impact on that entity redemption. It did not impact cross purchase. It impacted the entity redemption. This is kind of how the case played out, and there's more detail in here than we really need to get into. But suffice to say, we had a company that had an entity redemption, and this thing kind of blew up on them. The Connelly case was just it was a shocking case for the legal community. It did a complete 180 on how we handled past tense stock redemptions. The company, Crown Sea Supply, uh, owned life insurance policies on their two business owners, Michael and Thomas. And the buy-sell agreement said in the event of death, the company, Crown Sea Supply, would buy from the decedent's estate, and they would use that life insurance to make that happen. Before Connelly, we would have an offset value on the valuation from that death benefit. After Connelly, we do not. So what happens now is that the value of the life insurance increases the value of the business. What it did in this case is it resulted in an additional nearly 900,000 in estate taxes to the estate, and it increased the value of the interest that the family had to buy from Michael's estate. So the message there is when addressing Connelly, it's very important that you work with a good estate business planning attorney. Most planning attorneys are also business planning attorneys. That's why the two are interchangeable. The issue here is how does Connelly affect the plan that you have in place? If you already have a stock redemption agreement, um, let an attorney review that. It's worth just running that through the scenario to see how that would impact your plan. And do you have enough funding in the event that the Connelly impacts your stock redemption and the value that is transferred is going to incorporate that death benefit in the life insurance policy that's owned by the company? If, maybe you're in the beginning phase of your planning, and you don't have a stock redemption, you don't have a cross purchase, you don't have anything, um, consider the impact of Connelly and consider how life insurance increasing the value of that business at death will increase the amount that needs to be purchased from the estate. And I will not make recommendations, but this is something to talk to your planners about and talk to the financial professionals to, analyze it and run some numbers before you even go in to talk to the attorney, and then see where the attorney lands on Connelly and how they've adjusted their documents to make this work. It may be that they shift into, cross purchase with multiple policies for multiple business owners, or they do some sort of hybrid where we keep the funding out of the company. It's really important not to bring those two together for stock redemption, so that we're not increasing value for the estate. Okay, with that, how are we doing on your end, Matt?
Yep.
Okay, beautiful. Well, that is the end of my prepared discussion. And so we can sit on this disclaimer slide for a couple minutes if you want, or we can just move on and maybe talk about some planning issues or some updates. I'm going to end this. I'm going to try to end.
One
There we
question,
go.
kind of mentioned it about holding it outside the business. Can you elaborate on that more or?
Yeah, yeah, absolutely. So what we're seeing a lot more of is an insurance LLC. So business owners are creating a separate LLC from the operating company, and the LLC will own the funding that will ultimately take care of any cash flow needs that the buy-sell might create. And what that does is it keeps it out of the estate, or sorry, keeps it out of the business so that we're not increasing the value of the business by that death benefit. And yet, the family still has the cash flow, the liquidity. Um, that is one of the best ways to do this because what it also does is it incorporates some retirement planning too. Because later on, if that LLC is structured properly as a partnership, we can use permanent policies to supplement retirement when the business owner leaves the business. So
And
kind of a win-win all around.
can there be any tax consequences or deductions there using that LLC?
The tax implications are fairly complicated. The Cliff Notes version of that is if we're using an LLC taxed as a partnership, and that's fairly important, we can move life insurance policies that are currently owned by the operating business without violating some of our insurance rules. And that's super important so that we can protect the death benefit from being included in the gross income of the beneficiary. So we can move those policies, maintain those policies in the LLC. We use bonuses from the operating company in order to pay premium and make contributions to the LLC. Every premium that is paid or every contribution that's made increases the basis for our business owner. And then later on, this policy, if we have what's called a terminating event, in other words, our business owner is retiring, they're giving up their interests in the LLC. Terminating event happens. We can move that policy out to them. That's not a taxable event. They can tap into that policy up to basis without any tax implications. And then they flip over to loans. And those are non-recourse loans, which means they're not paid back. They're paid out of death benefit when the day comes.
Thank you. I appreciate you coming on. You got any questions? Anybody? Thank you very much, Amy. Yeah. We have any other questions? I'll just say this, Scott's probably gonna host an event down by him. We'll probably ask you to do this again for us sometime, so.
That would be awesome.
Great, great.
I love
All
working with you guys. You take care.
right, thank
All
you.
right. Bye now.